just take a few minutes to let people sign in, and we'll begin here momentarily. Okay. Give it another minute here. Okay. So I think we have everyone here. So I'll start here. So again, thank you all for joining today. Today is going to be our third and final session in this estate planning seminar series we've been hosting. So thank you to all of you who have been here throughout the series. And for those of you who may have missed the first one or two, we do have those up on our YouTube page, the Kendal at Home YouTube. And so if you want to go and check those out and revisit those, feel free to go ahead and look at those after this session. So today I am Ryan Anderson. I am the outreach manager here at Kendal at Home. Today we have with us Sue Woykin, who is the marketing and events coordinator for Kendal at Home, and she's going to be handling kind of the behind the scenes stuff on Zoom for us. Any questions or comments that you have, please feel free to type in the chat or in the Q&A portion, and we'll be happy to answer those at the end of our session. So feel free to type those in as you start to have questions come through. And with us today is our special guest, Meredith Sugar. Meredith is with Taft Law out of their Columbus branch. She is primarily focused on estate planning, wealth transfer, tax planning, that sort of area in law. And so, Meredith, thank you so much for taking the time out of your day, busy day, engaging in mom duties and working on that. So thank you so much for taking the time out of your day to join us for this.
Oh, well, thank you for having me, Ryan. And as I told Ryan yesterday, baseball duty calls. So I'm about 3 minutes from my arrival site, at which time it'll be easier for me to look at my PowerPoint here. But it's a short 1 mile drive, but so I can easily get started. And I think Ryan's going to share my screen that I have the PowerPoint today. It's as he mentioned, it's the third in our series. So there will be some overlap with the first two. Our first session, to remind everyone, was related to health directives. And the second one was related to trusts, which actually are a huge part of an estate plan. So you'll see some slides in this deck, and no doubt hear me saying things on this call that'll overlap with those other two sessions. On this one, I wanted to, I hope to tell more. I don't want to call them horror stories, but sometimes you have to scare folks into getting their estate plan started, because as I've always said, it's not fun to think about dying. A lot of times a client will call me and get the process started, and I'll ask them the questions that I need to ask, and they don't follow back up with me for 6 months to a year. And so, but as you see here on the first slide, if we can go to it, what percentage of us are going to die? I start every talk with this question. It's 100. And so it's good to get your estate plan done. It's always better to do it sooner rather than later. So many people put it off because, you know, they say, well, my daughter's getting married next year, and or my grandson hasn't visited. And you want to always plan as if something's going to happen to you later today, because estate plans are not, you know, concrete. They're easily changeable. And so it's good to get them done as soon as you can. I have a blurb in there on life insurance because it's part of it. You know, it's an asset that oftentimes people don't consider that does go into their estate plan. Beneficiary forms will, and we'll talk about those in a few minutes. Very important, related to the full estate plan. So it's kind of, you have to look at the big picture on not just a will and a trust, but how are beneficiary forms set out, and how all of that is done. And we'll talk about that today. So the next slide, please. So the main components of an estate plan, as everyone, you know, thinks, of course, is the will. And we're going to get more into the nitty gritty. But along with that, some very important ancillary documents, you know, the powers of attorney and health directives, which I'll just touch on briefly since we already mentioned them, beneficiary designations, and then the extra documents that are recommended 99% of the time based on the assets that folks have would be the trusts, and then really the titling documents to get assets into that trust. And so next slide, please. So the starting place, the will. 9 times out of 10 folks will have a will, but it is 20, 30 years old. It was prepared when the kids were babies, you know, when a lot of times when you were married to someone else. So it's always good to revisit it. And an estate plan is not something that you can do just one time and never look at again. It's unique state to state. So for example, if you move to Ohio from Indiana a few years ago, you're going to need an Ohio will. You know, states will respect each other's wills, but it makes it a lot tougher and a lot more expensive. So you want to have a will that is unique to your own state. It's also critical when a will is needed that it be the actual original. I've got a client right now coming in. Her will was originally drafted in Michigan, but they can't find the original anywhere. So not only had I recommended she have a new one because she has come to Ohio, but it's critical that it be the original. Otherwise, a probate court will put you through, you know, a lot of hoops in that case. A lot of times people assume that they don't need a will if they don't have a lot. And it's actually, that's actually the opposite. You know, I've got clients that have great net worth and their estate plans are so hatching down that they pass away and they're not paying lawyers and they don't actually need much from me or, you know, from lawyers or advisors because everything's been handled. And then what I hate to see is clients without as much net worth, you know, for example, a young couple that has $50,000, but they've never prepared wills and they, you know, they do or don't have small children and the legal fees are so expensive that by the time everything is said and done, that smaller net worth gets eaten up by lawyers. And also, as I always say, no one wants to pay a lawyer if they don't have to. So also, an issue of passing away without a will is, you know, second spouses or children from other marriages. If no will is involved under Ohio and Tennessee law, a spouse has the right to usually inherit it all. But if there are kids from a first marriage, you know, they might be entitled to half. It could end up leaving a surviving spouse with not as much as you would want or more than you would want. Also, to the extent people have that second marriage and try to and say, okay, well, we both have our own assets, so I'm gonna just leave everything to my kids and she'll leave hers to her kids. A spouse under Ohio law can elect against a will and go in and challenge and say he or she didn't leave me and I would like my half. And really the only way to avoid that is through a trust. So that would be another reason a trust is critical. Next slide, please. So what does a will cover? If you've got minor or disabled children, a will name a guardian for them. You know, it'll name an executor, the person that oversees. In some states, that's called a personal representative. But that executor person really would be the person in charge of making sure if assets are passing under a will that they're passing exactly as the testator wanted them to. A lot of times people will name their own parent or a sibling as an executor. And I like to always see a couple backups, one, hopefully even two, and oftentimes someone of a younger generation. Because you might have named someone 20 years ago that says, guess what? I don't want this job, so give it to someone else. So it's good to have backups in place. An executor can take a fee for the job that they're doing. The court usually sets what that fee is. But usually, as I mentioned, 9 times out of 10, a trust is the way to go. So the typical wills that I prepare will say there in the first paragraph, I, Meredith, hereby leave everything in my individual name to the Meredith Trust. And then it's really my trusts that would cover what happens to my property and how. So we call that a pour over will. The idea, though, with a pour over will is that the will is never needed. And the reason for that is because when a will is needed, you're going through probate. So having to use the will to send things to a trust will require probate. So what's recommended instead is, just that things are already in the trust, and we're going to talk about that. So I would say in the cases where I tell the client the will really is all that you need will be if a client comes in and says, look, I've got a condo, an IRA, and a checking account. And I say, well, if you don't want the trust, what we can do is title the condo to be what's called transfer on death. So it's kind of like a beneficiary form. Same with the checking account. And then an IRA, like any asset that names a beneficiary, passes outside probate anyway. So the issue then would just be that it would transfer to that person no matter what. So issues with that, for example, sometimes when that's happened and someone titles their condo and says it's transfer on death to my daughter, Jenny. Well, if mom and Jenny are in a joint accident and something happens to both of them, then the condo is going to have to go through probate because there won't have been a beneficiary at all. So next slide. So probate, the reasons to avoid it. I don't like it. Attorneys make a lot of money off of it. So I am usually selling my probate partners out of work when I recommend against it. But it's the last thing that a grieving spouse wants to do, or a child. We've had probate administrations that have taken up to 5 years. If there's any issue, I would say the quickest we've ever gotten one through is 4 or 6 months. With out-of-state children, it's a real hassle for them to come in, pay attorneys. And, the issue is that if you've got assets in different states, you could end up with a probate administration in each state. So you might be an Ohio resident, but if you've got a condo down in Hilton Head and it's never gotten titled into a trust, you're going to have a South Carolina probate and an Ohio probate. And, I had one yesterday with someone who had oil and gas interests in Canada, and that probate would have been a real nightmare. So by a simple assignment and putting those into a trust, you're able to avoid it. But other issues too with it are just it's public. Most people want privacy. Again, you just pay attorneys. If I've got a client with a really nice coin or art collection and they have to go through probate, that collection has to be valued. The court gets to appoint the appraiser. The estate has to pay the appraiser. So again, it's very easily avoided. And a lot of times attorneys will help prepare estate plans for clients, but not follow up with them on making sure probate is avoided by just titling assets properly or having that trust, because they know they're going to come back to them for the probate, where the legal fees, rather than the $3,000 to set up the estate plan, the legal fees end up being $50,000 to go through probate. So it's good to avoid it. Next slide, please. So again, as I've been talking about how to avoid it, where the assets are simple, it can be done just with simple beneficiary designation. So TOD, POD, which just mean transfer on death, payable on death. But the issue with that, again, is if your beneficiaries fail for whatever reason, then you've got issues. So it's a simple trust, which really takes no longer to prepare than a will would, and just states how you want your property to flow is 99% of the time the way to go. A lot of times, as I know Ryan's heard this a lot, at least, when I say the word trust, clients feel like I'm trying to sell them something, and this I always assure them it takes me no longer to do than it would have your will, and doing this for you and for me because I don't want to probate your estate. So I mentioned earlier the assets in other states and foreign assets can be subject to foreign probate systems, which is also a huge nightmare. Next slide. So as I've been mentioning, and I won't go too far down into the weeds, but the trust is really the way to go. Sometimes a couple together will have one joint trust. So if it's a husband and wife and they've got 3 kids and their wish is just, if I pass first, all to my sweetie and vice versa. And then when the second of us passes away, equally to our children. So sometimes a couple can just have one joint trust and it works really well. Usually the only reasons to split a married couple into 2 trusts would be if there's a tax reason, which I'll talk about here in a few minutes, or if they might have children from different marriages, or if their wishes don't mirror each other. So one spouse might say, well, if I go first, I want to leave 20,000 to the Humane Society, and then I want this for my cousin. And or if assets are kept separate, which is more and more common nowadays, then each spouse would usually have their own trust, just setting out their own wishes. Another great reason to have a trust is if you have minor children, and even if those children are grown, if you've got grandkiddos. So if one of your children has a 10-year-old, if you and your child are in a joint accident and you were just leaving assets to that child, their share, if they were also deceased, would flow down to their own child, and that child would take assets at the age of 18 once they reach adulthood. Most people don't want to give a large chunk of money to an 18-year-old. So trusts typically provide that, that a child, even though funds would be there for their needs, that they have to reach certain ages before they can have a full right to just go in and take the trust funds out. So the trust avoids probate, provides for children. You might, even if it's an adult child or anyone with special needs or creditor issues, or if you've got a child that you worry about their spouse, potentially taking advantage of any inheritance they would get, a trust provides a way to leave funds in and make sure that they're protected. Let's see. Okay, so thank you, Ryan. You're reading my mind. So trust, the kinds of trust I'm talking about right now are revocable, easily changeable. So as I mentioned earlier, there's no reason to wait to do them. Have them in place now as if something would happen today. And then all of the time they get changed. So I've got a client who probably changes hers 3 times a year, and she'll call and say, I thought Jenny was ready to inherit at the age of 30, but I think we need to push that age back to 35. Or disinheritance. Sometimes if they're a family falling out and someone is taken out of an estate plan. So they're easily changeable. A simple trust amendment oftentimes takes 15 minutes for me to prepare. The person who creates it is called the grantor or the settlor. The trust is treated as one and the same as that grantor. So it just bears their social security number. There's no special tax filing. The IRS doesn't want to know about it. So it's really one and the same. A lot of times people assume that a trust, if one is created, is going to have all of this, specialness to it or require special filings. And that's just not the case. They're actually very easy. It's just really, so for example, me again, I'm a Meredith individual, but I've also got a Meredith trust, and I've got all of my assets in the Meredith trust. So I kind of wear 2 hats in that regard. Irrevocable trusts, which I'll touch on a little bit here at the end. can be used for other purposes like gifting or life insurance reasons, or just, to set things more in stone. And there are some reasons for those, which I'll talk about here in a few minutes. Next slide. So as I mentioned earlier, a trust bequeaths your assets the same way a will would. I would say the norm is to provide for that spouse and then children. But if you're intending to give a gift to your church or whomever, those can be given directly through the trust. You might have wishes in there to give certain items of property to certain people, and that is all written right into the trust. When it comes to personal property, and I'll mention here shortly too, I like to have everything down to the toaster in the trust. So clients will receive from me just a one-page, it's called a bill of sale. And it will just say, for example, again, I, Meredith, put all of my personal property. So my things, my household goods, furniture, clothing, it could be artwork, coins, anything that's in the trust as well. And the trust will provide then that I could write a memorandum at any time during my lifetime to leave certain things to certain persons. So, right now in my late 40s, but if I reach age 70 and I decide that I would like my daughter to have a certain piece of jewelry, I would just write up a memo, and by that it could be something as simple as a sticky note, or just an email to my attorney that they could put into my file. So too, in a second marriage situation, a lot of times a client will say, well, I want to provide for my spouse right now, but I want to make sure that when she later passes, that anything I left her that she didn't use goes back to my kids rather than hers. And that's easily done as well. You can have assets in the trust that provide for that second spouse, and say the assets are there for their, we call it the HEM standard, health, education, maintenance, and support. If there's any concern, I always add in the language and the standard of living to which we've been accustomed. So that surviving spouse can't take the money and start going on, cruises around the world every year and blowing through all the funds, but it supports them through their life. And then the funds at that second passing could go back to whatever set of children or persons the grantor would want. Next slide. So in a trust, the income and principal distributions can differ. So for example, a trust might state that a beneficiary has a mandatory right to income, but that the principal is only there for health, maintenance, support, that sort of thing. So we call those either mandatory distributions or discretionary. So the trustee can have the discretion then on whether to distribute funds out. So we'll talk here about that in a minute, but that trustee role is going to be critical in that regard. For clients with kiddos who are minors, I usually recommend that they have what's called a pot trust, not so that the kids can smoke pot, but so that if older child has just gone through Harvard and reached age 22, and then second child is only 15 and the parents pass away, that second child might say, well, gosh, mom and dad, or even grandpa and grandma just paid for their college. Now I've got to pay my own out of my half. And so a pot trust allows the trustee to keep assets in one big pot until the baby of the family reaches age 22 or 23. And then it would divide into the shares. So withdrawal ages, I would say the average is that funds are always there for kids or grandkids for their needs, but those withdrawal rights, oftentimes they can get half of it at age 25 and the rest at age 30, or whatever ages. And this again often changes. So if you've got a 28-year-old who's just kind of gone off the reservation and is blowing money at the casino every night, a client will call and say, let's up their ages to 35 and 40. And so that's easily done. And sometimes especially with grandparents, they never give the children a full withdrawal rate. They might say, I love my daughter, Jenny, but she's not good with money. I want to make sure she doesn't blow through her trust fund and I want to make sure there's something left for my grandchildren. And so Jenny's fund might stay in trust for her lifetime, so that the trustee can distribute for what the trustee feels she needs, but there's never a full withdrawal age. And then at Jenny's later passing, those funds would be there for grandchildren. Next slide. So usually the provision is that where children pass away, their share would go down to their own children. So we call that per stirpes. But I've had clients where there are 2 kids and one of them has 8 children and the other has 1. And the family travels together a lot. So in that case, grandparents might say, well, if one of my kids passes away, rather than half of the half being shared amongst 8 grandkids and half going to 1, we would call that per capita instead, where they would say leave it in trust, and once the 2 children pass away, then let's split it up into ninths rather than half going to 8 and half to 1. So you can also, a lot of times, a surviving spouse of a child, because I would say normally clients want to keep assets in the bloodline, and if their own child has passed, they want it there for grandkids. But if your child has a spouse who is loved and part of the family, and the desire to provide for them as well, you can provide for a surviving spouse of a child. And then I always recommend, I hate to talk about it, it's morbid, but we call it the catastrophe clause, where especially with a family that all travels together, you want to give thought to if something happens to the whole family. If you don't set out what you would want, it would go through intestate law, which would be probate. But intestate law could mean that because all of your descendants would have passed, in that case, it would go up to your parents. And if they're not living, then down their family line. So that could be siblings, nieces, nephews, and occasionally persons you wouldn't want. So it's good to give thought to a catastrophe clause. And then sometimes in that case, folks will just say, if there's a full-blown catastrophe, then charity would be our option. Next slide, please. So the next one, as I mentioned earlier, the trustee's role, this is critical. This is the person that you're gonna trust to oversee the trust fund, distribute the funds at the time you've asked them. They're bound under fiduciary law to follow what that grantor wants. If they don't, it actually could be considered illegal. But because it also can be loosey-goosey, for example, if a trustee has the right to distribute for health, maintenance, and support, and they're working with a niece or nephew who comes to them and says, hi, Aunt Meredith, can I get apartment rent while I'm in college? And my apartment's going to cost $10,000 a month. My job as trustee in that case would be to say, gosh, that's really expensive. Let's look for something a little more reasonable. So that trustee, though, it's a huge position of trust. They may not want that job. So I always recommend to clients that you communicate that up front. So often a client will come in and have 3 children, and they'll say, well, let's just name my son trustee, and he'll handle the funds and distribute funds to my other two daughters. I always recommend that you talk to that son first, because he may not want the role at all. So for that reason, like an executor in a will, it's good to have backups named, just in case that trustee you've named can't serve in the role. The initial trustee, I should have mentioned earlier, an irrevocable trust is actually usually just the grantor. So for example, Meredith, I'm the trustee of my own trust. So the trustee I'm talking about here would be the one who would step in and act if I couldn't after I died, or if I became incompetent. So I've got a great one right now with a mother who has developed dementia. She's not happy with her daughter because her daughter has taken the car keys, and mom shouldn't be driving anymore. But right now, under the trust, the mom's still her own trustee. Her condo needs to be sold, and so daughter's trying to get the sale handled. but the title agent and I are working together on just how that will occur, because the mom's refusing to cooperate on the sale, even though she wants the sale to go through. But because they know she's incompetent to sign documents, we need her to step aside and resign as trustee so that the daughter can step in as the successor trustee, and she has named the daughter under the trust. But it's critical, like I said, that these documents get drafted as early as possible, when there's full competency with the person that you're going to want to step in, even if you do become incompetent. So the trustee job, while the funds are in trust, sometimes the trust isn't in place very long. So if a grantor passes away and has 3 adult children, the trust might say, upon my death, split everything in thirds and distribute it. And in that case, the trustee's job would be to get the house sold, distribute items, divide a bank account into thirds, distribute it, and their job may be done within a few months. Whereas a trustee that says, hold this in trust until Johnny has reached age 40 or whatnot, in that case, the trustee's job would go on for a while. So, and two, sometimes people say, well, let's just name both of my daughters as co-trustees, and that can work. I always ask clients to give thought to it, because if you've got, 2 co-trustees who don't get along or don't agree on, should we sell the vacation home yet, or should we keep it? Fighting can occur, and when that occurs, it ends up in court. So, you don't want to have too many cooks in the kitchen. The flip side of that is, if you've got 3 children and one is the trustee, and doesn't make distributions as liberally as the other 2 might like, they could end up angry. And so communication is always a great idea, to just where you're able or comfortable doing it, talk to the kids or the grandkids or whomever up front and let them know what you're thinking as far as where to go. If there is a big concern that they're going to fight over the role, other options for trustee are always, attorneys can serve, banks can serve, friends, accountants, trusted advisors. So in cases where you expect it could be sticky, oftentimes it's a good idea to name maybe a bank. Next slide. So the trusts that can also have extra provisions. So for example, a dynasty trust, which is expected to go on for a long time. You might have a distribution advisor or an investment advisor, someone that the trustee can have to kind of as a check and balance to bounce things off of and have their help and their backup in the decisions that they make. Once a trust does distribute its assets, it can be wound up and terminated. I mentioned that co-trustees work together. I typically, if there are 2 co-trustees, we require they act unanimously to get anything done. It can also create hassle. I know clients assume that it's more fair to name both daughters as trustees just to keep it fair. But if one daughter's in California and the other's here in Ohio, it may create more hassle than it's worth. So it's good to talk to the drafter of your trust on what would work best in your family situation. Usually there's a right of removal in the trust, where if there's a trustee who's just horrible, won't even distribute money for college tuition, that sort of thing, the beneficiaries can usually have the right to remove that trustee. But I usually require in mind that if they are going to remove a trustee, they've got to put a bank in place, because you don't want to have the case where 3 beneficiaries gang up on a trustee to oust them so that they can name their best friend, and do things that the grantor never intended. Next slide. So I briefly will mention a special needs trust for anyone with a child or a grandchild who gets government assistance, Social Security, or with a disability, to leave funds to that grandchild outright or child sounds equitable and fair, and you want to treat them the same way that you do everyone in the family. But then those funds would be subject to taking. So there are ways that we have of just making, if there are 3 grandkids and Johnny has a disability, Johnny's share would just be held differently. So rather than having an outright right to the money, his share would have to be, as I said earlier, a little loosey-goosey so that the government couldn't come in and say, well, those are Johnny's funds. He had the right to them, so we're going to take them. So that share would be held with a lot of discretion, entirely discretion on the part of the trustee on whether to ever give funds or not give funds or this reason or that. I put into those what's called a poison pill so that if by some reason the government was able to attach those funds, that Johnny's share would blow up, if you will, and get distributed out to other family members that you could trust to use the funds to care for him. Next slide. So titling assets into the trust. This is kind of the follow-up homework. I always tell clients they come in and sign their trust and think that they're done, but I say, no, we've got follow-up. So we give them a deed for any real estate to title that into the trust. The bill of sale, it's personal property into the trust. The one exception on the bill of sale is vehicles or boats, any kind of motor craft, because those pass through the BMV. Those usually too can pass outside of probate anyhow, but where you're a car collector or you've got 3 cars in your name, I always recommend to clients that they just take that title and on the back of it, put that actual car into the name of the trust, kind of like if you were selling it, and that keeps it out of probate. And then if and when something happens, the trustee then is the person who's able to just sell that vehicle. Investment and brokerage accounts are probably the most critical asset to put into trust. And it's so easily done, whether it's just a call to your person at Vanguard or Fidelity to say, gosh, I've got my stock accounts with you, put them into the name of my trust. Because when my paralegal has to put stock accounts through probate, even if it's a mutual fund, she's got to value every share of stock in that fund in the morning and the evening on the date of death. And it's, again, just legal fees after legal fees, where if that stock account was just in the name of the trust, that wouldn't occur. Savings and cash accounts are a little different sometimes because people want their checkbook in their name. So with those, it's just a simple trip into your bank branch to say, you know what, Chase Bank, can we take my checking account and just make it transfer on death so that if I pass away, it goes into my trust. If you're a business owner, and with this, a lot of clients will have, they don't own their stock through Fidelity or E-Trade or Vanguard, but instead they've got very old JCPenney stock certificates stored somewhere in a safe deposit box. Those also are a pain to go through probate. So you want to give thought to whether you have any business interests, because that you're actually an owner then of that company. Or if you used to own a yoga studio and you had it in a limited liability company, it's a simple 1-page assignment to just title that LLC into the name of the trust. IRAs, 401ks, and pensions can be, they're non-probate anyhow because they name a beneficiary. But these, like wills, oftentimes that beneficiary form was filled out 40 years ago and folks don't even remember whom they've named, or sometimes they've named no one, or they've named persons they don't intend. So a beneficiary designation will trump everything. It'll trump a trust, it'll trump a will. So you want to always give good thought to how your beneficiary forms are titled. If you've got 3 kids and you say, I want my IRA to all 3, then it's fine to just name those 3. Keeping in mind that if one of those kids passes away with you, their share would go to their own children under their own estate plan. So if that's not what's intended, then occasionally it's best to just name the trust as your beneficiary. Same with life insurance. I'll tell you, so often a child will come and say, you know what, we found an old policy dad had. It's only $10,000 of life insurance, but he never even filled out a beneficiary designation. So we've got to send the whole policy through probate. So always keep in mind who your beneficiaries are. Next slide. The financial power of attorney, I know we talked about these a lot in the first session, so I won't go too far into them, but a very necessary and powerful document. You want to have someone named in case you can't act for yourself. I actually prefer that clients draft them to not require incapacity for them to be used. So for example, mine does say, if something happens to me, Meredith, my sister is my power of attorney. If instead I were to say, or sorry, that's the opposite. If instead I say in mine, my sister is my power of attorney, and that will be far more useful to her, because if it were written that she's got to go in and prove that I can't act for myself to do anything, that takes time. I think, Ryan, you've probably heard the story. I had a client once who, she was close to passing away, and her children were trying to get things cleared up, but because the power of attorney said they could only act for her if she were incapacitated, we had to send it to the bank. They wanted proof she was incapacitated. We had to have doctors. By the time it was all said and done and they sent it to their legal department, it took 2 weeks and the woman had passed away. So the kids weren't able to even use that POA for anything that they could have used it for to help her avoid probate. So I always say, if you're going to give someone a power of attorney, you're obviously trusting them tremendously. So you might as well just make it current, trusting that they're not going to do anything with it that they shouldn't. It would be illegal if they did, but I'll say that, it is the document that can be used to rob clients. I had another of my horror stories a few years ago. I'd had a client who I had drafted for probably 15 years ago, and it was always the same daughter she named as executor and trustee and POA. Well, the other daughter called me and said, mom says she wants to switch it and make me her POA. So I said, I'll have to talk to your mom about that. And she said, well, she can't because she's unconscious and not mentally there. And I said, well, then once that happens, it's too late to draft anything new. So I'm sorry, we can't. And so this other daughter was not happy. She called and yelled, and then she called our headquarter office and complained that we wouldn't. And I'll tell you what she ended up doing. She went into LegalZoom, drafted one herself, dropped it off at my office, kind of like a na. So knowing, that something was up, really my hands were tied. But what I did instead was just notify my client's financial, her investment holder that I suspected that some shenanigans were going on, so that then it kind of put it into their hands on whether they were going to let the daughter use the POA to do anything wrong. I will say that if a bank or financial institution smells a rat at all with a POA, they won't honor it. So it's not a bad idea if you've had a lifelong relationship with Chase or Huntington Bank, to go in and let them know that, hey, I've named this daughter or son as my POA. Sometimes they're even on bank accounts. And then in those cases, the bank knows that they can trust them. Next slide. We touched on these in the first session as well, so I won't go too much because I want to leave time for questions. But the living will and healthcare powers of attorney, critical documents to have to name, the persons you would want to make healthcare decisions for you, whether they're end of life or not. Ohio's forms change every 6 years or so. So if you've got one that you drafted 20 years ago, it's very easy to just send your attorney your current information, what are the kids' current addresses and phones, and they can get that information onto the latest forms. Now the forms too have organ donation provisions and other provisions in them, which I won't dig down into, but it's good to be on the most recent form, and to then, once it's prepared, file it with your physician or the hospital near you. Next slide. Aging issue. Won't go too far into this, but so often clients say, well, I'm just going to give everything to my kids, and that way if I go into a nursing home next year, the government can't take it. The 3-year look back rule on that is now 5 years. So if you do that within 5 years of going into that home, they can get it anyhow. It's tough to do this sort of planning, and I suspect the folks I'm talking to aren't the in need of that type of planning anyhow. But I will mention, because so often clients assume that these revocable trusts help with the issue of whether a government could take funds if you're in nursing home care, and a revocable trust, the kind that we've been talking about, does not do that. Again, it's just one and the same as the client. The next slide, I just will also mention, similar to what I just said, these trusts and wills don't help you avoid the tax man. We have a federal estate tax. Right now it is set very high at $11.7 million per person. So basically what that would mean is if I pass this year with 12 million, the extra 300,000 is going to be subject to estate tax at a rate of 40%. So high net worth clients often plan around to try to avoid that. Biden's proposal, and then one that was recently submitted by Bernie Sanders, is to bring that exemption down to 3.5 million. So most of us estate planners expect that'll probably happen late next year. So, if you're in a situation where you've got 5 million, you might want to be talking with your tax advisor and attorney about using that extra 1.5, if it's going to come back down to 3.5. And gifting that amount out this year. So when I mentioned earlier, occasionally there are reasons to have two trusts with a married couple if they are in an estate tax range where they've got enough net worth. It's good for both husband and wife to have their own trust, even if they mirror each other. And the reason for that is just to make sure they each get to fully use their own exemption. Next slide. Almost done here, so I can leave time for questions. The gift tax, I think most folks know that you can give away up to $15,000 a year per person to as many people as you want. So if a lot of high net worth clients that are probably going to be subject to the estate tax will say, well, gosh, I need to get rid of it and get it out of my estate. So they'll give $15,000 a year to 10 different grandkids. Also in Biden's proposal is proposing that amount, that $15,000 per year, can only be used twice. So in that case, you could only give 2 of those grandkids the $15,000. Gift tax is unified with estate tax. So that's why I think I'm not going to have much of a Christmas this year, because a lot of my high net worth clients, knowing that the 11.7 million is going to come back down to 3.5, are going to be giving that extra, giving away as much as they're comfortable giving away so that they can use that higher amount. Because what the gift, if you do go over the 15,000 a year in a gift, it eats away at your estate tax exemption. So the two are unified. Just very briefly at the bottom, if you are in a high net worth situation, I recommend greatly that you talk to an advisor sooner rather than later, because I think all of us are going to be really swamped at the end of the year. Just helping clients come up with techniques to lessen that estate tax burden. Again, if you're over a 3.5 million range individually, or if you're married and you and your spouse are over 7, there are techniques that you can use to help use that extra exemption. I also should have mentioned that Biden proposes that the estate tax be raised from 40% to starts at 45% and goes all the way up to 65%. So a couple more slides. Just I think I've touched on these throughout, but people oftentimes hold off on doing their estate plan just because they've got all these questions here on this list. Who do I want to leave my property to? When? How old do they have to be? Do I have to treat all 3 kids equally if one of them wants the vacation house and another one doesn't? The answer to equal is not always fair, and fair isn't always equal. So these are just things to consider, but not to let hold you up, because you should have your plan either way, and then change it as you go along if your mind changes on different things. Insurance needs, I won't talk much about that, but if you are in an estate tax situation, sometimes life insurance can help pay that estate tax bill. It's good. I'll note there in the bottom, a lot of policies now are outdated. The premiums have gone up so high and they just don't make sense anymore. I'm not an insurance expert on myself, but if you've got life insurance floating around that's questionable in that regard, I definitely recommend you talk to your insurance expert. Next slide. If you do have life insurance to help pay an estate tax, you want to make sure that it's in its own, what we call an ILIT, an irrevocable life insurance trust. Otherwise, for example, if I have $20 million and I say, well, gosh, I'm going to take out a $5 million life insurance policy to help pay the tax in case I die. If I just take out that policy on its own, that 5 million just gets thrown into my bucket and then it gets taxed. So it's like a vicious circle. But instead of doing that, if instead I just have it owned in a certain type of trust called an ILIT, I can avoid that. And then next slide, I touched on this already with the unity of our estate and gift tax. And again, just I note there in the bottom, the estate gift tax exemption has changed 80 times in the last 120 years we've had this tax. So it changes, so it's good to keep up to date. In 2012, it was set to come back down to $1 million. So a client with $2 million was looking at paying 40% of that extra million and having a $400,000 tax bill to the IRS. So it's good to keep it in mind, talk to a tax advisor if you're fortunate enough to have the problem of having a large enough net worth. And then just a couple more slides. Next, just the GST exemption I'll mention briefly on the next slide, Ryan. Sometimes clients will say, well, I either don't like my daughter, I want to leave things directly to grandkids, or my children are wealthy, they don't need my money, it's going to go straight to grandchildren. The IRS also has what's called a generation skipping transfer tax. So if you try to skip a generation and go straight down to one, they said, well, we're going to miss a bite at the apple, so we don't want that to happen, so we're going to impose another tax. But we each have a GST exemption as well. And if you are in that situation, I'll just mention that it's advisable to talk to your advisor on what you can do to avoid that tax. And then the last two slides here, these are just two techniques. Again, if you've got the problem, if you will, of having high net worth, a couple of the types of trusts we can use, which are irrevocable, can help lessen your estate. Still transfer assets down to heirs and children, but help avoid those. So these kind of two different types of trusts. And then the last slide here, I mentioned valuations. So whether it's a coin collection, an art collection, a business that's been in the family, it's good to always know the value of what you have. I've had business owner clients for certain that will come in and they've had a pizza shop in the family for 30 years and they don't know what it's worth, and it turns out it's Donato's or something like that. So it's always good to have knowledge of what the value of your assets are. So those are all the slides in my presentation, and then I hope, and if we run over, it's fine. If anyone has any questions.
Yeah, so Meredith, thank you so much for the presentation. I'm going to stop sharing right now. So thank you so much for this presentation. There's a lot of information that I learned. I had no clue about some of this stuff, and it's been amazing hearing you speak for the last 3 months on this to us and just go through it all. So
happy to.
There's a couple questions coming in. The first one is sometimes people, their year to year doesn't change too much. It kind of looks like things aren't changing. How often should you either review or change your will if you feel as though nothing substantial has really changed?
I've gotten some estate plans that were done 40 years ago and done well enough that nothing needed changed. But because we as attorneys, I would say the power of attorney is a classic example. Each time we learn a lesson from a client on some provision that should or should not have been in those documents, our documents change. So if you've not had anything substantial in your life that has changed, I don't think you need to look at it annually, but it's good to call your estate planning attorney every 5 years and say, here's what my net worth is now. Nothing's changed in the family. Are any of my documents, should they change? So maybe every 5 years is a good checkup period, and they shouldn't have to go in and spend an hour reviewing it. I typically can remember what they had, and it takes just a few minutes to let them know. But otherwise, good to keep it in mind. If anything in the family changes, though, that's always a reason to make that contact and change to your documents.
And sometimes I'm even thinking about myself. Sometimes I look at your year, I'm like, oh, nothing changed. But then if you take 5 years ago, completely different.
Yeah.
So sometimes you
Right.
don't realize it. So good to just review it. The next question is, I think they were talking about interstate when you were talking about like wills being like an Ohio will or stuff being in different state. Can you talk a little bit more about that?
Yeah, just so states, the documents that I recommend get changed if you have moved states are 100% of the time you need a new will. That's for your state. So some states, for example, require notaries, some don't, some need 2 witnesses, but then they have different provisions. If you haven't done that and you're now in Ohio and you have an old Texas will, eventually an Ohio probate court will honor it, but it's going to take them a long time, a lot of legal hassle and legal time. So if you've moved states, you most definitely want a new will. They want their state's health directive, so a new living will and healthcare power. And usually I just pull up a new financial power of attorney as well. They take 5 minutes because the states can be really sticky about that as well. So those 4.
And the last one here, and if anyone else has any questions, please feel free to put in the chat or the Q&A, and I'll put up Meredith's info again at the end here. But even if an estate is not subject to estate tax, is it wise to come up with a potential tax plan before death for the future trustee because of higher tax rates on trust income after death on forms like 104?
Like forms like what?
They put in a 1041 form, maybe something in the lines of like a 401k, stuff like that.
Yeah. You're right. That's a great question. I talked a lot today about estate tax. We also have an income tax. So where funds are going to stay in trusts, that trust is subject to income tax on any income it doesn't distribute. So that's another reason you want to have a savvy trustee who, even if they're not good at it, they're knowledgeable enough to get a tax advisor or financial advisor that knows, hey, I should distribute this amount to this beneficiary because they're in a lower tax bracket than the trust is. Because trust tax brackets, they're slightly higher than individuals, but they reach that maximum level a lot earlier. Also, I will mention that Biden's tax proposal wants to do away with what we call the stepped up basis. So if you've got stock that you bought for $10 and now it's worth $1 million, under current law, when you leave that to your daughter, she's going to take a basis of $1 million because she gets a step up, and so she won't have that capital gain. Biden wants to do away with that. So it's good. So in some cases, maybe it's better to sell that stock now while capital gains rates are lower, convert it to cash. So it's good to talk to your financial advisors on that. It's a great question. Yeah.
Sounds good. So I'm not seeing any other questions or in the Q&A or chat. Again, Meredith, thank you so much for joining us these last 3 months and talking to it. I personally learned a lot. I'm sure a lot of our viewers learned a lot as well on it. And thank you again for all your insight. I'm going to put up Meredith's info just one more time in case anyone has any further questions and would like to get in touch. There's her contact info right there.
Well, thank you. And thanks for bearing with me while I did this travel to my 15-year-old's baseball. They give us about 10 minutes notice on when and where it'll be.
Absolutely. And thank you for taking the time out of your day for this. And we wish you guys all the best of luck in the game and tournament.
Oh, thank you. Okay, thank you.